All right. I think we are on. I think I'm unmuted. I'm looking off to this side because that's where my control stuff is. And Megan has dropped some welcome messages in the chat. So I think we are good to go. All right. So it is Tuesday, and I will constantly need to be reminded. We are going to talk about some stuff in digital forensics, and you got to make it clickbaity. But we're also going to talk a little bit about Barry Bonds and his influence on digital forensics. Believe it or not, specifically, we'll talk a little bit about privileged documents, efficient review, that sort of thing as we get towards the tail end. But some of this is going to be some history, and we're just going to analyze the case that Barry Bonds was involved in. All right, so I got to select my slide deck there. I had these slides in as placeholders. Normally, like this is the transition to some of this stuff is it's not my favorite, but that is me, Justin Tolman. I'm the forensic subject matter expert and evangelist here at Xtero. Xtero, we produce FTK. So that's us. Yeah, see, these are placeholder slides and or transitions, and I don't like them. So I've been in forensics for quite a while. I don't know if that's quite a while, but 12 plus years. It's a while. Former law enforcement forensic analyst for the Ohio Bureau of Criminal Investigation. So worked there for a little bit. Also worked a little bit in the Lafayette, Indiana Police Department while I was getting my master's in cyber forensics. So really appreciate that experience as well. Just good times had by all. And then if you want other content that I've created or just more forensic content on your YouTube feed, you can subscribe to Justin Tolman Forensics or Xtero Media. Justin Tolman Forensics is a work-related stuff. I do post stuff other than just FTK stuff, though. I have a little behind the button thing. I have more stuff coming up here soon. But it is all forensics oriented. Xtero Media is where I post all my stuff as well. It's kind of double posted, but if you're interested in like e-discovery or data privacy and stuff like that, there could be some of that over there as well. And then of course we're on LinkedIn and other social media platforms. Connect with me on LinkedIn if you want. Okay. So yeah, intro. All right. So Barry Bonds, what influence did he have on digital forensics? But before we get to Barry Bonds, we're going to take a look at another case, and we've got to go back. We got to go way back to the late 70s, early 80s, and talk about the United States. United State just won. Come on, Justin, who built this? United States versus Tamura. And this was decided back in December 10th, 1982. This is about just under 5 months shy of my birth date, literal birth date. So I was not around for this one. So there's a company, the Marubeni American Corp. Okay. And what they did is they sold Hitachi phone cables. So basically Hitachi made the cables. Marubeni was an American subsidiary of a Japanese company who then resold these cables in the US. So specifically in this case, we have the Anchorage Telephone Utility Company, who's government owned, that the only way that they could purchase stuff in many government agencies are the same, where you have to go through competitive bidding, right? Where even if you're like, this is what we want, you have to bid it out and whatever, right? It's just the way it is in a lot of things. So that's how they would buy their stuff. Okay. Now, for about 8 years, Marubeni won a lot of contracts, maybe even say most of the contracts, for a total of $9 million in contracts from them in phone cables, which in the 70s, I don't know, I should have calculated for should have calculated for inflation. Somebody in the chat, if you're bored of my presentation already, What's 9 million in 1978 to now dollars? You can put it in the chat. We'll see if that's a lot of money. It doesn't seem like it, but who knows? All right. So the rules with this competitive bidding is you have a project, and even if you only want to buy a certain type of cable, uh, from this company, you had to bid, like the bidder had to submit prices for every conceivable cable or piece of material that might be used on this job. Okay. So, the risk here would be is I need cable A, and that's, like, and I bid it at a value, but cable B was a low thing because I'm like, oh, maybe they'll need cable B, and then you would lose the bid because somebody else bid right and they didn't even care about cable B and all this sort of stuff. So Marubeni bribed an Anchorage Telephone Utility Engineer, ATU engineer, to know which cable they actually needed, so that they would quote they could quote that cable high, but everything else would be super low, and so it would make their bid actually come down, um, you know, uh, below everybody else, even though the actual cable that they needed would be a moneymaker, right? So this went on for at least 8 years, where they were getting these kickbacks and these bribes. Okay, so the person who at least got their name on the case, Lay Raymond Tamura, managed the department that handled the bribe payouts at Marubeni. And when Tamura's secretary discovered that there were these bribes, and yeah, okay, so that's a significant amount of money. So thanks, Matthew. I mean, like, that's, we said we got about 42.5 million. Hey, okay, like, of structured, maybe manipulated bid wins. Okay, so his secretary discovered that this was going on and informed the FBI. What a buzzkill. I know. All right. And so, this investigation kicked off. So there we go. We're now to all the United States versus Tamura. Somebody should proofread this. I blame Bella. So on June 8th, 1978, they served a warrant on Marubeni looking for contracts related to kickback and bribery. And to find the relevant records in the accounting department, the agents had to perform 3 steps. So the funny thing is 1982, we're still in kind of the early days of the computer era, as as it is. But so they had to review some computer printouts. They were probably very few, locate vouchers that corresponded to this stuff, and then find and check the corresponding information to those vouchers. All right. Now, remember, we're in a paper era, but we're going to tie this into digital, as it is. So the FBI go in, and there's just tons of stuff. Okay. And they realize this is going to take forever. And one thing we need to talk about at this point, and it may even still be now, but since we hopefully learn from the past, we kind of write our warrants in that we're going to search and seize and possibly remove stuff from up the premises, right? We're going to go search and seize it and take it out. Well, prior to this, it may have been a thing, but it wasn't really a thing. Anyway, so the FBI realized, hey, we don't really want to take all of this, but we also can't stay here and dig through this mountain of data trying to find it. It will take forever. So they go to the employees of Marubeni and say, hey, how about you help us find stuff and we'll get out of your hair? The FBI said, hey, if you don't help us, we're going to take everything. Okay. Which will impact your ability to do business because you're not going to have any of these financial records. And when they refused, the FBI weren't bluffing, and they took everything. They took 11 cardboard boxes full of printouts, 34 file drawers of vouchers, and 17 drawers of canceled checks. And the government made the argument that this mass seizure was justified because the documents were intermingled, and that's going to play into our our computer forensics here in a little bit. Also, I just want to point out that this is AI generated art, given like what did I say, like bribery and stuff, and it doesn't know how to draw dollars. So at least the one that I used. So so anyway, yeah, so they go in, they take all this stuff and argue that, hey, we can't go in and pick through this stuff because we don't have time to go through it all. Tamura ended up getting convicted on 59 counts of those things that you see there. No shortage of charges. But he appealed on a couple things. But the relevant thing to what we're talking about today is that the government seizure of all of the stuff was excessive. Okay. That, hey, they were looking for this type of information, but took all of this other data. Now, the decision on the appeal, he was still like, listen, he was still found guilty. They didn't reverse any of the decisions. But what they did was they said, okay, hey, given the, and we're just, there was other complaints, but given what we're talking about today, we're gonna zero it into this that applies to us. On this topic, the two things they said was, okay, hey, given what you knew, fine, whatever, but going forward, that you need to sort those things on site. You know, you can't go in with a warrant for X and then seize literally everything and bring it out. And then the other thing, if you need to remove it from the location, you actually need to obtain another warrant. And like I said, now basically learning from maybe this is out of our collective memory, but most of the time when we write our warrants, we say, hey, we're going to go in, we're going to search and seize and remove from the premises, right? And then we document everything that we took. Then the second piece of feedback was relating to searches and not seizures. They say in here, and I'm just going to read it, in a different context relating to searches, not seizures, we recently approved a procedure whereby law enforcement officers bring in lay experts as consultants to facilitate the on-site search for documents containing complex or technical subject matter. Okay. Now, because remember, as they went in there, they asked the employees to help them determine what was this or what was that. And, they refused. And so, hey, they're saying the government needs to just take the initiative here. And if that's the case where you have to go through that stuff, just bring your own person. And hopefully we're doing that now, right? So like I said, I worked for Ohio BCI in a lab, right? I was an analyst that sat in a lab with no windows, that sort of thing. But occasionally there would be cases where, hey, we need to go out and we need to be able to go through this. So they would drag one of us out of the building. We would go out on scene to help sort through that. Okay. To determine, okay, hey, we need to take this, we need to take that, not this, not that. Okay. So a lot of that kind of came from, or is quoted as coming from United States versus Tamura. They're saying, hey, we understand that in this case, FBI agents aren't going to be a pro in every single thing. Yeah, a comment in the chat, a forensic accountant. Okay. In this case, they could have a forensic accountant go out with law enforcement agents and do their thing. I don't know the first thing about being like a detective. Well, I know the first thing, you just got to be a detective, but like that's not my skill set, but I know computers, and the detective may be a great detective, but doesn't know computers. And so, with our powers combined, you can get this job done. And so we have United States Tamura on this to kind of set that stage of, hey, have a professional that can go through, that's not the case agent, by the way, and say, okay, here's the information that you should care about. Okay, so that's the first thing that we need to remember, is that United States versus Tamura said, bring an expert that can help you go through the stuff on site. And if you need to take it off site, you have to have a warrant to do so. That's pretty common nowadays. Remember, we're talking early 80s. All right, so you're like, what are we talking about here? Who knows? Another AI generated art, though. They don't know how to do feet in this one. Maybe. It looks painful. Same with hands. Okay, so Barry Bonds, very talented baseball player. Got his stats up here. I'm actually not a baseball person. I enjoy watching it with friends. I'm more of a social watcher, but um, kind of a simpler time in the early 2000s, even though we're post September 11th in this. Apparently, our government had the time and the cycles to focus on who was doing steroids or not in MLB. Um, I wish that was kind of the pinnacle of what we had to worry about today. That would, okay. But what happened was we have this really prolific baseball player, and especially like, the home run champion, and he kind of gets wrapped up into the steroid scandal. Okay. And there's three major ones. I just chose Barry Bonds because he was the kind of the home run king, that sort of thing. But there was the three most prolific players in this investigation were Barry Bonds, Jason Giambi, and Gary Sheffield. Okay. All three of them were kind of the ones that were kind of the focus. But, as it says here in 2003. So first off, in 2002, the government begins an investigation into the Bay Area Laboratory Cooperative, or BALCO. Okay. BALCO was a company, an agency, cooperative, as it says here, that worked with the trainers of baseball players to, improve their performance, whether legitimately or chemically, right? I think we have the facts now that they were probably using a bit more chemicals than what was appropriate for that. So the government begins an investigation into BALCO to figure out, okay, are the baseball players in fact doping? Okay. Recently, just shortly before this, the players union and all that sort of stuff had renegotiated a new kind of steroid punishment thing. This is kind of off to the side, but why it's such a big deal to the players of what we're going to talk about. And it was basically something like, okay, the first time you get caught with performance enhancing drugs, it was something like a slap on the wrist. It was like, you can't play 10 games, which in baseball is like, what, a week? And then if you get caught like 2 times, it was a 50-game suspension. Okay, now we're talking, or maybe the first game was first was 50. It's like 50, 100, and then a full season. Okay, something like that. And so that represented, some serious issues. So the players union files to quash a subpoena. They obtain a warrant for 10 players. Okay, we're going to kind of skip through. And the problem is once they obtained the warrant for the 10 players, they had a reason to go into the I didn't mean to hit that. The comprehensive drug testing location, because they needed the results for, again, these 10 players, of which included Barry Bonds, Jason Giambi, and Gary Sheffield. Okay. And then the other of those 10. What happened, though, was when the government went in, they're like, oh, it's on a computer. I'm not going to extract just the information from these 10 players. I'm going to take the directory, okay, containing the results for more than 100 baseball players. And, we'll just take a look through that and see what's up. Netflix has a documentary on called The Untold Hall of Shame. I'll have to check it out. So yeah, nice. They go in and they take all these records and they start to go through it. Well, what happened was when they did that, they started saying, oh, hey, it's not just these 10 players. These other players have also tested positive for steroids and stuff. And now the players union is obligated to punish them. And they're like, oh, hold up, like I shouldn't have been in this. And so it represented financial damages to these, and they felt like their privacy rights had been violated. And they were right. So then we have some appeals. So we have the Central District of California, which is called the Cooper decision. We're going to take a look at this one specifically. It has some of the good stuff, but then Bonds is charged with obstruction of justice as they try to get more information about the steroid thing. And that's why his is the namesake for this, because he does end up getting convicted for obstruction of justice as it goes through. And then you have in 2009, U.S. versus comprehensive drug testing, which is this whole thing kind of put together. Okay. They take the decisions of these things and, go forward. Okay. So again, we have, in this case, we have computer data. We've kind of moved into the quote unquote modern era here. And so we're going to see how this applies to us as computer forensics specialists. All right. As we go into, we have a lot of data involving a lot of people that aren't associated with our case, right? So how do we narrow it down? So let's go over United States, this time all the states, it looks like, good job, versus comprehensive drug testing. And again, this was submitted, kind of decided finally in 2010. So in 2002, the federal government commenced an investigation of the Bay Area Lab Cooperative, or BALCO, which is suspected of providing steroids to professional baseball players. And again, like I mentioned earlier, the MLB had entered into this bargaining agreement allowing for suspicionless drug testing. And what that meant was they had a lot of tests in comprehensive drug testing, okay, this company. And what they were trying to do is determine, in this case, it wasn't going to be a punishing thing. It was just going to be try to figure out this right here, whether more than 5% were testing positive or not. Okay. But once the government overstepped and found all this stuff, they, their identities were out. And then at that point they had to be punished. So we scanned down a little bit in the document. And so the government obtained a warrant. Okay, cool. To go into comprehensive drug testing, CDT, and get those 10 players who they had probable cause for and, review that data. However, they went in and, like I said, took hundreds of players of data. And this is a line I thought was interesting, and a great many other people, because, they're just doing drug testing, and the government now had access to a lot of people's records. So what we need to remember is that when we go into these things, we need to be able to filter down. So they got a warrant, they go in, and instead of sticking with the 10, they take just everything. So MLB, or the Players Union, filed 3 kind of injunctions and different things to try to get the government to not be able to do this. So Central District of California, District of Nevada, and Northern District of California, with those 3 judges, which if you were to go read this, which I'm sure you all want to go for some light reading, these are the judges. And so when we refer to the Cooper decision or the Mahan decision or the Ilston decision, they're named after the judges there, which is standard operating procedure, you guys know. So all of these judges found issues with the way that the government executed the warrant on this computer data that contained not only the 10 that they were looking for, but a lot more. Okay. Which is, why we're here. So within the Cooper decision, he found that the government failed to comply with the conditions of the warrant designed to segregate information as to which the government had probable cause from that which was swept up, only because the government didn't have the time or facilities to segregate it at the time and place of the seizure. Now we're going to find out they sort of tried, but not really. Relatedly, Judge Cooper determined that the government failed to comply with the procedures outlined in our venerable precedent, United States versus Tamura, which we just talked about. Remember, hey, what was the second one of that is bring in expert. A forensic accountant was mentioned. In this case, since we're talking now computers, you're going to bring a computer forensic specialist, a cyber analyst, or whatever you call it, right? you know, your CSI guy that's trained in computer forensics to go through it. All right. And so they didn't do this in this case, or at least what they did, and we might get to it here, is they used their computer forensics specialist and then handed the data straight to the case agent unfiltered. Okay, unfiltered. And we're going to talk about the importance of filtering that. I mean, we're kind of dancing around it now. So, but yeah. So I'm not going to read this whole thing. That's a lot of stuff in there, but this is stuff that most of us will know. Okay, we're kind of taught this early on. And sometimes even like why we need to take everything, right? And I'm not necessarily disagreeing with that. So the sum up of this is that, it says here the government explains computer files can be disguised in any number of ingenious ways. And they talk about changing the file extension, or it could even be deleted or moved around, all the stuff that we as forensic professionals know, right? Just the basic stuff. You can hide pictures in Word documents and misname stuff. And so the government here is arguing that because of these different things, we have to go take something at name or face value and expect that or whatever. Basically, we don't trust them because they're obviously doing this wrong. Why would they stop? Whatever. Okay. They talk about, compressed passwords, all that sort of thing. Okay. And so that's what the government started with as their justification for taking everything. And that is not so bad at first. Okay. Because yeah, we might create a full disk image, even if we only need, a certain type of information, because we don't know where on the disk that it is going to be. That's fair. Okay. And so Judge Cooper kind of goes with that. All right. So once the items received, the requirement of the warrant that any seized items not covered by the warrant be first screened and segregated by computer personnel was completely ignored. So remember, that's that part of Tamura where, hey, bring in a professional to sort that out. And the same thing goes for us with computer data. If you have a situation, it could be HIPAA, right? It could be client attorney privilege. It may be something like this where you're going in to get information from a drug testing center, right? Where, okay, there is someone or someones that you need information for, but that doesn't give you, license to go out here. So instead, the case agent himself reviewed the seized computer data and used what he learned to obtain the subsequent search warrants issued in Northern California and Southern California. Okay. And this is where the problem happened. And we call these like clean or dirty teams. You may have other names for them, privileged and reviewer. If you have other names, drop them in the chat. I'd love to know. That whole idea of, okay, hey, listen, we had to seize the whole drive. That's true, because we don't know where it's at. But we're looking for these 10 people. You give it to Justin in this whatever, and you say, hey, find any information related to these 10 people and kick that out either into another data set. We'll talk about this here in a little bit, or mark everything else as privileged or create a batch, whatever the case may be, to where now the case agent can review only the data that is covered by the warrant. And then I am never really, other than did you image it and did you process it and did you kick this data out? Those are the only questions that I could be asked, or that would be in my report. I would never be asked about the content or anything like that, because I would be on the dirty team, right? Like I've seen other people's stuff and that would not be cool. Okay. But they didn't do that. They basically had the computer person, what I'm guessing here is image it, process it into a digestible format, and then just straight up give it everything back to the case agent to continue to run it. Okay. So they didn't use whatever. So my favorite line out of here is that the Supreme Court here said that the government was too clever by half. And I had to look up that saying. It's not something I have typically used, but the too clever by half, what they tried to do is the government argued that they were complying with Tamura. But once they started going through, it was plain view. And so at that point, it's like, oh, here it is. I can also look at their stuff. Oh, here's another one because it just happened to be here. All right. And so Judge Cooper and this court say that they were too clever by half. And basically, that means that you think you're arrogantly clever and really pleased with your excuse, your reasoning, but in the end, it's actually wrong and not as clever as they think. But so they threw some major shade at the plain view exception in this case, in the way that they did it, because here again, the Tracy directory that's referenced here contained the 10 that they wanted, but also contained basically everybody else in the MLB and a bunch of other people. Okay. And so they said, hey, you have the professionals, you have the ability to have had it screened by a neutral third party, and then you only investigate what mattered. And so plain view only basically operates when it is plain view and there's no other way around it. And so the court rejected the plain view exception on this, saying that no, it doesn't apply because you've done these other things wrong. You didn't comply with Tamura, and you had the ability to comply with that and chose not to. And so, because you were in a space you shouldn't have been, the plain view now doesn't apply, which we have to remember, for plain view to apply, you have to legally be in that space in the first place. And they weren't, according to the court. Here, scan down a little further. We're now in the Mahan feedback. So it was unnecessary for the case agent to view any data for which the government did not already have probable cause, because there was an agent at the scene who was specifically trained in computer forensics. And that's us. Okay. And so that's what they were saying. Hey, plain view, doesn't apply because you could have had your computer guy get only the stuff that you needed and then handed that back to the case agent who knows the case. And that's really how it worked with me. Not the filtering aspect, but I was just the digital guy. I wasn't a, like investigator that did everything top to bottom. They would just hand me digital stuff and tell me what to give them, and then I would give it back to them. And so if we were limited, you could say, hey, only return stuff of this type, and we do it. So anyway, just be aware of that. Anyway, the court's saying, hey, this is your exception to the plain view, and it's no good. Doesn't count. Okay. So even though Barry Bonds was convicted of obstruction of justice, they found that the government had vastly overstepped and didn't do their thing. So what can we take from that? Is if you're dealing with information that potentially could contain data from other sources or about other people outside of the scope of your warrant, or just flat out information outside the scope, you need to have a neutral third party, my drink is empty, go through it and filter it out, possibly. It just depends. Of course, you'll know your case the best, but it's better to filter down and make sure that everything's done by the book, because you want to win your case the right way so it stays one, okay, or whatever, right? You don't want to mess that up. All right, so as we've been talking about this, we've talked about filtering this data out. We have all this information. We have content data and context data. And I don't know how many of you came into the forensic space via academics or came into it via police work and then moved over into forensics. But the academic side of the house, I super appreciate my time in school and I learned a lot. But sometimes we get caught up on things and then you get out in the field and you're like, wow, we spent a lot of time on stuff that you don't really think about, at least directly on. And one of the things that at Purdue we talked about a lot, and I ended up writing a paper on it or whatever, it was content data versus context data. Okay. And there's different, depending on your area and different things, there's different levels of protection for each type of data. We'll start with context data. This may or may not be protected depending on where you're at. And then again, you have to look at the sum of this information can also result in some privacy concerns. But typically, context data is things like that have lower levels of privacy protection, just names, phone numbers, address, etc. Now, in our current example, like where they had all these drug tests, okay, the fact that they had tested an MLB player is really not necessarily of a violation of anyone's privacy rights, because we knew, and the MLB and the players union was very transparent, that they were basically testing all MLB players to try to get an idea of how much was positive, what percentage was positive. So seeing an MLB player's name on the list without knowing, we'll get there in a second, is not necessarily a violation of privacy. And so if they had returned just the list of names that were on there with no information, maybe not such a big deal. Maybe. Okay. The other type of data, content data, these are the artifacts. It's hard to use the in a definition and not use the term in this case, but this is the content. Like in our example here, in our case, the problem was you didn't just have their names, the team they played for or whatever. You also had their results. Did they test positive or not? And that's what the government started to use, was the content data to go after other baseball players. And that's what the government or the court struck down, is like, hey, whoa. You went past and into content that you actually didn't have a warrant or authorization to go into. Okay. And so there's different levels of protection for the different types of data that you might be looking at. Okay. So, one of the things I didn't quite get time, and I wanted to put it in here. Maybe we'll do a follow-up or something, like a mini one on this, on Cyber Social Hub or something. But the cool thing about like SQLite queries is you can actually write a query to redact the content if you're allowed to have the context. Like maybe it's like, hey, we want to know this person's texting behavior because we want to be able to show a normal use case in a day, but we don't have, like, it would be a violation of the privacy rights of other people that they are talking with if the messaging or if even the name or phone number are there. And so what you might have is the context data would be, hey, a text message was sent or received at this time, but I'm going to redact out that information. And it's really cool. You can do that pretty simply with SQLite queries, so that you can show the overall picture while still protecting the content data. And that's very important and plays into this. It's just I had too much going on and didn't have the time to write the SQLite queries to show you up. I should do a shorter one, and I'll just post it on the Social Hub as an addendum, an appendix to this presentation. But yeah. So privileged data review. So we have this case, right? We have this directory full of MLB players and their drug screening results. How do we take a look at that? How do we manage our neutral third-party review and filtering? Well, there's a couple different ways. Obviously, I just mentioned SQLite queries, but what if it's not, stored in a SQLite database or whatever? Well, the first thing is to have either a separation from the examiner and the reviewer. Okay. Typically your reviewer might be the case agent in this case, because they are the ones that need to make a determination about how the investigation is going to go forward. Okay. So if you're typically the investigator and do everything top to bottom, for a lot of cases that may not matter. Okay. But if you're going into something like this, where the government did, and they need to be filtering, well, you may go in and you may seize the computer, right? And And now you're going to have to hand it off and say, okay, listen, there's a lot of data on here, a lot of drug testing. We need these 10 players. I need that exported out and into a digestible format so that I can now review just the 10 players that we have a warrant to examine. Okay. And it's going to require that separation. All right. So if we take a look at it, and in this case, we're not looking at necessarily files, we're looking at a chat, because most of the evidence that we're going to be examining in 2023, 2024 going forward, I doubt it's going to change much, is going to be mobile-based evidence. So I wanted to show like, hey, how does our software, how would we go through that? So right now we're logged in as like the examiner. Okay, I can see all the stuff. And so in this chat message, we've got just like 5. And I'll point out, hey, class starts in 14 minutes is the first one. And hey, you still have this number is the last one. And what we could do, and obviously this stuff is just random. Okay. But I can go through and I can say, hey, these ones here, these messages are privileged in here. I'm going to flag those and say, hey, listen, I'm going to give this back to the case reviewer, but these 3 messages don't fit the criteria of the warrant that I was given. So I need to crush these out. So I'm going to mark those as privileged. Okay. And so when I have a reviewer user controls here, and I say, okay, for the case agent who's going to come in, who's my reviewer, they need to be able to look at the stuff. I'm not going to allow them to view anything that I marked as privileged. Okay. I don't want them to be able to see that. So now when they log in, here's that class starts in 14 minutes. Remember, we had 3 messages in between, and hey, you still have this number. Those are just not shown to them. Okay. They're left with only the messages that fit in with the scope of the warrant. Okay. This way, the case agent can do their work, focusing on those 10. Okay. And not, hose the other ones that you don't have probable cause to search their stuff or read their texts or whatever the case may be, right? Any out of scope stuff. So this, mark it as privileged that way, and then adjust your user permissions so that they can't see it. All right. And the nice thing about this is it's all stayed in the software if you have that kind of setup where they can log in either on site or through a secure VPN or something. So, all right. I think portable case can be a great solution to this thing. We're gonna take a poll here, and I realized too late that this platform that we're all watching on has a poll system, but I also use Minty, and we'll talk about it in a second. But portable case, obviously, I would assume that everyone has used portable case at some point if they don't use it all the time. But what it allows you to do is kick out only the data that matches the warrant to the case agent. Okay. Allowing them to stay within the realm that they should. Okay. Let's take a quiz here. I'm going to present. There we go. Okay. So if you're paying attention, if you're still here, we'll see how many. Go to minty.com. It is 100% anonymous. This doesn't capture any data other than what you put in here. Okay. Not device data. You don't have to log in. You don't have to have an account. It doesn't IP, nothing. Okay. So none of that. So you go to minty.com and just put in this code up here. And then as you guys put stuff in, it'll populate in. You can do it on mobile, computer, whatever. So, how do you use portable case? And I'm asking just to kind of get an idea of what the community does. But are you exporting all files and then you never see it again? You just kick it out the door and then, whatever. Or do you export all files, expect the reviewer to return for sync back, so that you can see, or do you only do a couple files and never see it again and whatever? So, oh, interesting. So a lot, at least, what we got on here voting is not using portable case. What I like about portable case, but it does require a little bit of extra work, because I totally get export all files, never see it again. We hear that quite a bit. Okay. The the other side of that story, well, first off, the nice thing about that is it frees you up to work another case, maybe one that requires more work. Hey, we've got to do data recovery and we got to do all this junk that requires cyber forensic expertise, right? The flip side of that is, are the people that you're giving them to trained? Maybe, right? Maybe. But you kind of, hopefully they get what they get, and it works out. But okay, I'm gonna so yeah, it's interesting to me that the I don't use portable case is as high as it is. It seemed to me that most were kicking it out. Now, that's not a bad thing. I like that you're keeping it and you're working your cases and that sort of thing. Portable case can be, like I said, a two-edged sword, but it's really interesting to see how it plays out. But in the realm of portable case, with what we're talking about, okay, you can go through, like, let's say you had this directory full of drug result testing. The idea here would be, okay, I've got this thing. I need to go through and I'm going to include all the records that deal with these 10 players, and I'm going to kick it out to a portable case. And now I can give it back to the case agent and say, hey, here's the portable case that, deals with these 10 players. Bookmark what you care about, report out, whatever the case is. If you bring it back, cool. If not, also cool, I guess. And go from there. But you've separated that data, right? You separated that data from the case agent of, this stuff is not pertinent to what you're doing, and this stuff is, and therefore you can still get your case without violating these rights and potentially costing you your case because you got a little overzealous in that space. Okay. So portable case can be a really powerful tool in these, if you don't have something like FTK Central, which allows you to collaborate without moving your evidence around and that sort of thing. So don't underestimate portable case as, a way to utilize this third party, neutral kind of filtering system. Okay. And if there needs to be more computer work on that stuff, that's where it can, I understand, get a little trouble. Like I was fortunate at BCI, we had a lot of examiners. So if one person was the initial person doing the filtering and then they needed more computer work done on the clean side or whatever, well, another one of us could go and work with them that hadn't seen all this other stuff and still be neutral with the case agent and applying only to whatever. Sometimes that's not the case, and so it can get a little sketchy, I know, but I didn't write the rules. This court did, among other things. So, and again, there's a lot of other case precedents throughout the nation and stuff. This was out of California, and their Supreme Court for their judicial district there, the federal judicial district. I'm not sure which one it is off the top of my head, but it's on the thing. I guess I could look it up. But yeah, but there's a lot of these different kinds of cases, and it's pretty much standard now that Ninth Circuit, there we go, that you need to have this division of duty. And there's a lot of software solutions out there and different ways to accomplish it. It's kind of up to you in what you feel is the best way to do it. But I think um, you know, either cloud or intranet based stuff like FTK Central, or if you're going to go offline, portable case, in any platform, portable case is a great system. Or I mean, we could go totally old school and just kick out the natives, create an export. I have done that. Okay. Hey, I need all this document based from this user financial documents. And we're kicking it out to our forensic accountants, and we're just giving them the natives on a DVD drive that they're going to load up and work with, because that's what they were comfortable with. That's good as well. But the idea here is that you want to get what you need to get while simultaneously protecting the rights of those that, at least for now, you can't have. Okay. I don't know if there's any Q&A. We had comments in the chat, but that's my 50 minutes. Megan, was there any questions? Or if there's any questions now, go ahead and drop them in either to the chat or Q&A, and we can go over it. And then we all, Matthew gave us some homework. We all got to go to Netflix and watch Untold Hall of Shame to get the Netflix version of this. I'm going to be real with you. Their production value is probably a little higher than mine. I'll take that hit. Yeah. Okay. So I haven't seen any questions pop up. I'm going to switch over to this tab. Nope, we're good. Again, connect with me on LinkedIn if you have any questions or something that pops up later, or comments, or want to talk forensics or whatever. I'm always down. Chat forensics. So yeah. Anyway, that's what I got today. I hope it was a little bit interesting, a little bit of history, how we kind of got to where we are, and a little bit of like considerations, for how we should approach things today. But yeah. And I'll see if I can find some time. Usually have some time at the end of December, and maybe I'll make an appendix with the SQLite stuff that you can use to redact, which I think is kind of fun. So I'll post that on Cyber Social Hub. Okay. Well, have a great week, and we'll see you again. Cyber Social Con.